Hello friends, welcome to EduSaathi, our partner in education. In this video, we will be starting a new concept of law of torts, and we will be discussing the basics to this law of torts and the defenses available against the offense of torts. So let's start. First of all, tort is a very different concept. It's an uncodified law. By uncodified, I mean that there is no statute available or any law available throughout this world which will provide for the provisions of this tort like it is available in the other laws in a country or even around the world. So the tort has been derived from a Latin word, tortum, which literally means twisted. So any conduct that is twisted, wrong, not straight, unlawful and not right is included in the offenses of law of torts. So we will understand how the concept of law of torts has evolved from the situations and cases and judgments given by the judges throughout this world. So as a member of a civil society, we have a right to live freely as we want to. However, our right to life and freedom should not hinder any other person's right. So we owe a duty of care towards each other that our right and our freedom or our conduct should not harm any other person while enjoying their right to life. So as a member of civil society, you cannot do anything wrong which will harm any other person by taking a defense that I have a right to life, I have a freedom to do anything. So if it hinders anybody other person's life, you cannot take this defense that it's my right to life. So your duty of care should be taken towards every other person, every other member of a society. Law says that you should not violate the legal rights of other members of the society. If you have a right to life, the other person has also acquired the right to life from the law of land. So you cannot violate the right to life of other person. The law of torts is based on the principle of ubi jus ibi remedium. It says where there is a right or where there is a wrong, there is a remedy. Jus means right and remedium means remedy. Wherever there is a right and it has been violated, there will be a remedy to that violation, and the person violating that right will be held responsible for violation, right? So the law of torts deals with the claims by private persons' rights. You can have a claim against other person against the violation of your right. So it's an offense. It's an offense against a private person, and private persons take up a case against other persons in violation of their private right. Let's start with the definition. The definition of law of torts says that a tort is a civil wrong for which you get unliquidated damages. So we have segregated this definition. This is a very plain and simple definition. It says tort is a civil wrong for which you get a unliquidated damages, right? So before understanding this definition, you should understand the terminology used in law of torts. These are the words which are most important and will be used throughout the concept of law of torts: injury, damage and damages. Injury, otherwise, if you go by the literal meaning, also means a damage or harm. But in case of law of torts, injury means violation of right. Violation of legal right. And in case of damage has attained its literal meaning, that is harm or loss. So there's a difference between injury and damage when you discuss the law of torts. Injury would mean violation of legal right, and damage would retain its actual meaning under the dictionary meaning, that is loss or harm. Other words which is used during the torts is damages, like it has been used here, damages, right? Damages would mean compensation sorry, it's not working properly. It would mean compensation in case of law of torts. So by segregating the definition of law of torts, we will discuss the different parts of this definition to understand the whole concept of torts. First of all, we start with civil wrong. Civil wrong means committing an act which injures or violates somebody's legal right or someone else's legal right. So before understanding civil wrong, we will understand the difference between civil wrong and other wrong which is done in society's criminal wrong, which will help you understand the concept of civil wrong better. Let's go to the next slide for this. This is the difference between civil wrong and criminal wrongs. Civil wrongs are less serious in nature. However, criminal wrongs are more serious in nature. Let's take an example here. Example is negligence. If you are negligent, then the crime offense of negligence is less serious as compared to murder, right? So the offenses which a person does under the law of torts are less serious in nature as compared to the crimes done under criminal wrongs. Law of torts deals with the private rights and duties of an individual. However, criminal wrongs deal with the offenses against society as a whole, right? So the scope of criminal wrongs is broader and more serious in nature as compared to the civil wrongs. The suit under the civil wrongs is brought by individuals. Like when you have civil cases, in those cases the party's name would be X versus Y. However, in case of criminal wrongs, the suit is brought by state. For example, in case of a rape, it would be X versus state of Punjab, X versus state of Maharashtra, X versus state of UP. So in that case, state is taken as a party, right? Or state, if there's a case of murder or rape, it would be state versus X. Like state is bringing about the case against that person because it's an offense against society as a whole, like we already discussed. So in civil wrongs, it's a civil suit. Under criminal wrongs, it's a criminal prosecution. Under civil suit, you get damages. Damages we already discussed means compensation. So you get compensation under the civil suits, or maximum to maximum you can get injunction, like you can stop the person from doing the act, or in this case you get punishment, like you get imprisonment, or you have to pay fine, and that kind of punishments are given under criminal wrong. So this is the difference between civil and criminal wrongs. By this you will understand that civil wrongs are less serious in nature, and these are the violations of private rights of individuals, and this reminds a person of his or her private duties against the other member of the civil society. Let's go back to the previous slide. Next concept which you need to understand is the concept of unliquidated damages. Unliquidated damages and liquidated damages. We discussed in the definition that it's a civil wrong where you get a unliquidated damages. Unliquidated damages means the money equivalent to the damage suffered. Damage here means, like we already discussed, is the harm or loss suffered by the person against whom the tort has been committed as a result of injury, that means violation of legal right, and which is not determined. By not determined, it means that the amount which you will get for the commission of a tort is not predetermined. Like we take an example. In case of contracts, there is a contract between two parties. In contracts, the amount which will have to be paid by the person who breaches the contract is already determined, and what court has to do is whether the person has breached the contract or not. It is the decision of the court which it has to take on basis of the circumstances. However, in the case of torts, it has not been determined. So the amount of damages to be paid by the tortfeasor or the person who has committed the tort would be decided by the court. The damages are on the discretion of the court. On the other part, like we already discussed, liquidated damages means compensation has been previously determined or agreed by the parties. It happens in the cases of contracts and other trust related contracts. In those cases, while entering into a contract, the compensation is previously agreed by the parties. They decide that if I breach the contract, I shall pay this much amount to you in after breaching the contract, and vice versa, right? Another concept which we need to discuss, like I had mentioned during the examples, is that injunction is also a order by the court which a defendant by which a plaintiff would ask the court to order the defendant from stop committing the tortious act. For example, it's an act which a neighboring person keeps on doing, and then you ask the court to stop that person from doing that act. It's another remedy which is available under the law of torts. You get compensation also, but in case of a continuing tortious act, you can ask the court to stop the person from doing that act. For example, your neighbor wants to build a wall blocking the road, right? It would be a continuing tort. If it's blocking your road, it's blocking your way to road, then in that case you can go to the court seeking order of injunction, and court would say that your neighbor should be stopped from building the blocking road, right? Blocking wall, I'm sorry. So under the law of torts, it's a civil wrong. You get unliquidated damages, that is compensation, and other than damages, you can also ask for injunction from the court of law. Let's discuss the essentials of a tort, or how a tort has been committed. First and foremost essential in a tort is an act or omission on the part of defendant, and a tort is committed when you either do an act or you omit to do an act. First, we understand how an act would amount to a tort. For example, you're doing something which you're not supposed to do. For example, you are supposed to, you're supposed to drive your car on a left-hand side, but on the other hand, you drive your car on the right-hand side of the road. That means you're doing an act which you're not supposed to do. You're not supposed to drive your car on the right-hand side of the road. That means you are doing an act which amounts to tort. So next is omission. In this case, you do not do something which you are supposed to do otherwise. In this case, you can say that you were supposed to, for example, take care of something which your principal has asked you. That, for example, you've been asked to take care of a house by your owner. You're working for somebody, and you're asked to take care of the house, but you fail to do that, due to which owner suffers some damages. In that case, it would amount to an omission, that you have not done the act which you were supposed to do. In that case, it would be omission of the act which you were supposed to do. So first essential is act or omission on the part of defendant. You have done something which you were not supposed to, or you have not done something which you were supposed to do. So these are the two cases in which the tort first essential would be satisfied. Next is, this act or omission must cause injuria. Injuria is a Latin term for injury. This must cause injury to plaintiff. So injury is a Latin term for injuria is a Latin term for injury, which we already discussed, that this act or omission must violate the legal right of the plaintiff, right? So second essential is that there must be an injuria. Third is, consequent to injuria, plaintiff may or may not suffer damnum. Damnum is a Latin term for damage here. Latin for damage or loss or harm, like we actually discussed. Consequent to this injuria, plaintiff may or may not suffer damnum. The use of word may hereby states that this essential is not compulsorily, it cannot be taken as a essential of a tort. It's a may or may not condition, that it might result in damage or might not result in damage. The absence of damage would not mean that the tort has not been committed. So there can be situations, for example, in case of trespass, if somebody enters your house without your permission, you might not suffer any damage, but it's a injuria. It's a violation of your legal right, but there might not be any actual harm or loss or damage to you. So in this case, damnum is not a essential. It may or may not be there in case of tort. For this injuria or damnum, injuria or damage, and or means it can be either only injuria, or it can be injuria and damnum. So damage is not compulsory, like we already discussed. For this injuria, the plaintiff may recover damages or compensation. He is entitled to take compensation or injunction for the injuria he's been inflicted, for the injury that has been inflicted upon him during the offense of tort. If there is an injury, there will be damages. If there is a violation of right, there will be damages, like we already discussed, ubi jus ibi remedium. Where there is a harm, there will be remedy to that. You will be entitled to take damages. Law of torts protects the rights. For example, we have already discussed, in case of trespass, you have a free right to reside in your house, but if somebody enters your house, he's actually violating your right to reside there. So there might not be actual damage, but your right to reside has to be protected. So the person would be entitled for the tort of trespass and will be asked to pay damages to you, even though there is no actual harm occurred. So these are the essentials to the law of tort. First is act or omission on the part of defendant. This act must result in injury. Lastly, the person is entitled to recover damages for this injury, and they may or may not be damages from the injury. So we while discussing, there was a confusion. You might have confusion that in what cases it would amount to the tort. There are 3 situations in tort cases where you will understand how tort would be committed, how injury and damage affect the commission of tort. If there is an injury also plus there is a damage also, in that case there is a tort. Thus you are entitled to take damages. If there is injury and there is no damage, that means there is a violation of right, but you have not been inflicted any actual harm. In that case also you can say it's a tort and you will be entitled to take damages and injunction. But lastly, if there is injury, if there is no injury and there is damage, you have been inflicted the harm, but there has been no violation of right. In that case it does not amount to tort. You can understand this whole 3 situations by differentiating between the 2 rules which are used in the law of torts, where the damage and injury is determined. First is injury sine damnum. Injuria means injury, sine means without, damnum means damage. Sine is a new word here. It means without. Okay, so it means violation of a legal right but no damages caused. In this case, there is a violation of legal right, like we already discussed in the case of trespass, but there is no actual damage. Tort is committed. Yes. Why? Yes, it is. Tort is committed if there is injury but there is no damage. Next rule is damnum sine injuria, damage without injury. Like we already discussed, if there is a damage but there is no violation of legal right, in that case tort is not committed. Injuria is absent, that's why tort is not committed. In this case there was injury, which is most essential to the offense of tort, but in this case there is no injuria, so it would not amount to tort. For example, running a competitive business. If you are running a business in a society and somebody starts that same business in on the opposite side of the road in front of you, and that is competitive business, it would not amount to tort, because everybody has their right to trade, right to commerce, and you cannot say that this person is infringing my right and he's causing me damage by starting a competitive business. It would not amount to tort. So this is damnum sine injuria. There is a damage but there is no injury, that is no violation of legal right. So these are the 2 rules through which you can understand whether there is a tort or not, whether the injury has been inflicted or not. There are various types of torts. We will discuss them one by one, like nuisance, negligence, defamation, malicious prosecution and trespass. There are other few torts which we will be discussing in next slides. Defenses to the tort claims. By defense you would mean that somebody has put a put a allegation on you that you have taken some kind of a tort, and you have some, for example, if somebody puts a allegation on you that you have trespassed or you have been negligent while doing any act which has caused a harm to that person. So in this case you can take all these defenses which are stated here, all these 8 defenses, that is voluntary non-fit injuria, plaintiff is the wrongdoer, inevitable accident, act of God, act of private defense, mistake, necessity, or act under such statutory authority. So these are the defenses which you can take to prove that whatever act you have done that does not amount to tort, with pretext to all these defenses that you were right while doing these acts. And then in that case you would not be asked to pay damages to the person who has put an allegation on you for the tort. Let's discuss the defenses one by one. First is voluntary non-fit injuria. Voluntary means consent, non-fit matlab let's discuss the definition first of all. When a person consents to the infliction of some harm upon himself, he has no remedy for that in tort. He consents to the infliction of some harm upon himself or any property of his. There is no remedy for that in tort. These points will explain it better. This means I know there is a risk and I agree to suffer consequent harm due to that risk. This would mean consent, which is a term for voluntary used in the defense. The consent may be express or implied. It could be that you might expressly say that I consent to this harm, or there must be any implied consent to it. Right? Next is I indeed suffer the exact harm to which I consented. The harm should be the one which you consented to. It should not be any other harm. Right? So I cannot hold the person who inflicted such harm responsible. Non-fit, that means you are not fit to take the problem to the court because you have consented to the injury yourself. Then you cannot hold that person responsible for such harm. The tricky areas involved in this case are that consent must be freely given. By freely given, it means it should not be forced, defrauded consent by the other person. You should have given the free consent to the harm. No agreement to suffer on account of negligence of defendant. There will not be any agreement to suffer on account of negligence of defendant. It is not applicable to rescue cases. We will take an example for the whole concept of voluntary non-fit injuria. For example, you go and see a match, cricket match. You go to a stadium and start to watch a cricket match. In that case, you have impliedly consented to the harm or prospective harm which could be occurred to you during the match. That is, when a batsman hits a six, the ball might land upon you and you will be inflicted some harm, and you actually know that this might happen, and you have consented to that harm. But in future, if the ball hits you, then you cannot hold the batsman or the other persons responsible for the act of that harm responsible, because you have consented to the injury. On the other hand, if there is a broken chair, you have not consented to that harm, so in that case you can hold the management of the stadium responsible for the harm occurred to you. The harm which you had been inflicted upon, you have not consented to that is broken chair. This means that it would not amount to voluntary non-fit injuria. This would not give the defense of voluntary non-fit injuria to the defendants. The last thing we discussed was not applicable to rescue cases. The voluntary non-fit injuria defense is not applicable to rescue cases. For example, you go into a building to save someone and suffer burn injuries. Person causing fire cannot argue that you knew there was a risk involved and willingly took that risk. So in this case, it would not apply. The person who has caused the fire cannot take a defense that this person knew that fire is there and still he entered into the building. In that case, the defense would not work. That person will be liable for the burn injuries or other injuries that has been inflicted upon the person who volunteered to rescue the persons trapped in the fire. Let's discuss the problem. Principle is, as per the principle of voluntary non-fit injuria, person who is aware of a risk and assumes the risk voluntarily cannot claim damages if he suffers on account of that risk. Facts of the case are, Mr. Ram went to see a motor car race being held in Brooklyn on track owned by Suresh. During the race, there was a collision between two cars, one of which was thrown among the spectators, thereby injuring Mr. Ram. So there is a injury, right? So in this case, like we already discussed, the case of cricket match, you know that there are chances, and it's a very common practice that while racing, the cars collide between each other. So it's a very common factor that, so you actually impliedly consented to the fact that any harm that is inflicted upon you due to the collision of two cars, the other person, that is Suresh, who owns the track, cannot be held liable for that harm. So let's take the options available here. First is, Ram can claim damages from Suresh. No, he cannot. Like we already discussed, he has actually consented to the harm that is inflicted upon him due to the collision of cars. Second is, Ram cannot claim damages from Suresh because he impliedly took the risk of such injury, and the damage being inherent in the sport, which any spectator could foresee. He could foresee that there are chances of collision of two cars, and in that case he has actually consented to the harm. So the danger which is there is inherent in the sport. Like in the case of cricket match, the ball being hit to the person due to a six by a batsman is inherent in the sport. So you have consented to it. So this option could be right. Let's take other option also. Ram had only knowledge of the risk, but he had not given his consent to the inflict harm. So we had discussed in the principle that it can be an implied or express consent. So this cannot be an option, because in this case there was a implied consent to the inherent danger in the sport. So this is the answer. Ram cannot claim damages from Suresh because he has impliedly consented to the injury due to the danger which is inherent to the sport. Let's take another principle. It says, no court will help a person whose case is based on an illegal act. That means, when a plaintiff himself is a wrongdoer, he cannot hold defendant responsible. Let's say I suffer an injury or damage. I say that injury has been inflicted upon me by the defendant, and it turned out that I myself was responsible for the injury and defendant had nothing to do with it. For example, we can take the case of trespass, right? Trespass. I enter into somebody else's house. There was a warning, beware of dogs, which is very common in case of the houses where beware of dogs. It's very common. Somebody who owns a dog would put a warning that beware of dogs. Despite of that warning, I enter into somebody else's house without their permission, and I got bit by the dog. In that case, I cannot hold the person owning the house responsible because it was my fault. Because I entered into the house, first of all, without permission, it was trespass. And then second, there was a warning. The problem, the fault was on my part, not on the part of the defendant. So this is the principle where it says that plaintiff is the wrongdoer and I cannot hold the owner of the house responsible for the injury for the harm which has been inflicted upon me due to the dog bite. The tricky areas involved in this principle are, if the cause of injury is defendant and not plaintiff, this defense will not work. Defendant is not allowed to do anything just because plaintiff is the wrongdoer. If the defendant has done something wrong, in that case this defense would not work. If the plaintiff is the only person who is responsible for the harm or injury, then the defendant would not be held responsible. But if the cause of injury is defendant, in that case this defense will not work. Let's take the same example. I trespass, you trespass into my house and I let my lion loose on you. In first case there was a dog but I see that you are entering my house. I let my lion loose on you. For the harms that would be inflicted upon you, I will be held responsible in this case. The principle here says that defendant would not be allowed to do anything just because the plaintiff is wrong. Just because you are entering my house, it would not entitle me to let my lion loose on you. Even though there is a ferocious dog, the dog which I know would bite you or harm you in any other way, I cannot let my dog loose on you intentionally just because you are entering my house. So in case the plaintiff is the wrongdoer, defendant would take this defense against the plaintiff in the court of law. But if the defendant has done something which has harmed the plaintiff, in that case this defense would not work. It's very simple defense. Next defense is inevitable accident. Definition here is an unforeseen, unexpected and unavoidable injury that happened in spite of reasonable care taken by the defendant. There are three factors which has been stated here. It should be unforeseen, unexpected, unavoidable injury which has been inflicted upon the defendant despite reasonable care. There should be reasonable care taken by the defendant. Let's take an example. You go hunting with your friends, bullets are fired, and a bullet glances off a tree, hits you, provided that bullets were not fired negligently and that firing was not result of a negligence. Here you can say that you went out on a hunting, you fired bullets. Obviously you have gone out for hunting, you will fire bullets, but the bullet glances off the tree. It hits the tree and then takes a turn, hits you, somebody else, one of your friends. It could hit one of your friends. But the factor which needs to be considered in this care is, in this whole process, is that there is no negligence involved. If there is negligence, you intentionally hit the tree and then it glances off and hits your friend, in that case this defense would not work. But you were hitting an animal, but the animal went away, moved from the place and hit the tree. It was an inevitable accident. The defense would work. So the whole thing which matters here is reasonable care or the absence of negligence. There should not be any negligence and there should be a factor of reasonable care. That person has taken reasonable care while doing an act. In that case, this defense would work. Let's take another example. A splash of mud ruins your new suit as a car drives by, provided a driver did not negligently splash the mud. So in this case also, the factor of reasonable care and negligence would come into play. It's in the scene that if the person is negligent, in that case he would be held responsible for the offense of tort. But if he's not negligent and has taken reasonable care, in that case the defense would be available to the defendant. The tricky area is that it must be an absolutely pure accident, right? Never presume that if it's an accident, it must have been inevitable. There are chances that accident could be avoided, but if that the chance of avoiding the accident has not been used by the person, then it would not be the defense of inevitable accident would not be available to the person. Let's take an example for this. Principle is, when an injury is caused to a person by an event that could not be foreseen and avoided despite reasonable care on the part of the defendant, and the defense of inevitable accident can be used. Facts of the case are, Sonam is a professional acrobat, which means that she is a professional and she does her act very well in a circus company. One day, while performing her stunts, she could not catch up the rope thrown to her and was thrown into the crowd, right? She fell upon Mr. Hans and both were seriously injured. Hans files a case against Sonam and circus company. So let's decide this case on the basis of the principle. It says that the event could not be foreseen and avoided despite reasonable care on the part of defendant. So in this case, there are two defendants. First is Sonam and second is circus company. Let's take the options. First is, Sonam is liable for her wrong performance. No, so Sonam is a professional acrobat and she did not do it intentionally. she herself has been injured, so it's an accident on her part. She took reasonable care while performing, and this could not be an option because she cannot be held responsible for the wrong performance. It was just a accident on her part because she could not catch up the rope thrown to her and was thrown into the crowd. Both Sonam and circus company are liable for Hans's injury. We already discussed that Sonam cannot be held responsible because it was an accident on her part. So this could not be an option because in this case both parties are held responsible. C is only circus company is liable. Why circus company should be held liable? Because in this case circus company can foresee that there are chances of, because there's a human effort involved, there are chances that that person might not be able to catch the rope due to some reasons. So the circus company should have taken reasonable care and should have provided for the reasonable space and arrangements so that the person is not thrown into the crowd in cases where the person is not able to catch the rope. They should have provided for any net or sponges available on the ground so that if the person falls off while performing, that person is not thrown into the crowd. Rather, in this way the injury could have been avoided if the circus company had taken reasonable care. So this could be an answer. Last is none is liable since it was an accident. We already discussed that it was an accident on the part of Sonam because she took reasonable care and she could not catch up the rope, so she is not responsible. But the circus company is liable for not taking the reasonable care and making the arrangements for the foreseeable accidents which could happen due to the person who is performing. So in this case, right answer is only the circus company is liable for not taking care of the fact that if the person is thrown, if the person is not able to catch up the rope, so that person is not thrown into the crowd. Rather, there should have been nets provided or sponges provided for the cases by the circus company. So Mr. Hans can claim damages from circus company only, not Sonam. Next principle is act of God. The definition of act of God is: act of God is an act occasioned exclusively by violence of nature without the interference of human agency. It is a kind of inevitable accident, except instead of human hand there are natural forces of extraordinary proportion involved. It's the whole principle is kind of similar to inevitable accident, but in this case there is no human interference or human hand involved. It's the natural sources which play their role, and it's the extent of natural sources can be extraordinary proportion which will result in the harm to the society or human. Vis major is a latent term which is used for a natural and unavoidable catastrophe that interrupts the expected course of events. It is used interchangeably with the act of God. You can memorize this term because the words which could be used in the problems is vis major or act of God. These are the terms which are used interchangeably, so these are similar. Let's explain it further. There should be no human interference in case of act of God. For example, an angry mob hits somebody or kills somebody. In that case there is no act of God involved because there should be no human hand involved. It should be natural resources. It could not be anticipated. For taking the defense of act of God, the act should be unanticipatable. It should not be it should not be foreseeable event. If it could not be anticipated, it could be guarded. If it could be anticipated, it could be guarded against. For example, if there is a anticipation by the weather department that there could be a heavy rainfall tomorrow, so in that case the harm to the human could be guarded against by keeping them indoors. So it should not be an event which cannot be anticipated. Extraordinary occurrences of natural forces, it should be extraordinary, and the proportion of the natural forces should be extraordinary, which we already discussed before. Such extraordinary natural forces which could not be anticipated and cannot be reasonably guarded against. For example, tsunami. If we say that it was not anticipatable and it could not be anticipated by the weather departments, and could not be reasonably guarded against due to due to its nature of unforeseeable. So the event should be of extraordinary occurrences by natural forces, extraordinary by the standards of that place. For example, extraordinary heavy rainfall, earthquake, and cyclone. So these are the extraordinary standards, and it depends upon the place. For example, if there is an arrangement in a country, if they build such buildings which are which are not which do not come to ground due to earthquakes, because there is the technology is developing day by day. So in that case, the earthquake would not be that extraordinary event, and it would not cause such harm as it could harm in India. So it would depend upon the place where such event has occurred. Reasonable care and inability to anticipate are independent conditions. Reasonable care is different from its anticipation, inability to anticipate. So reasonable care to the extent of anticipation must be taken. Anything beyond that is beyond the control of human. It can be given as a defense of act of God. So the principle says that it should be unforeseeable, and it should not be the event which could be anticipated. However, if there is an extent of anticipation, if there is an anticipation to some extent, the reasonable care should be taken to that extent. For example, if there is an anticipation of tsunami, there had been an anticipation of tsunami, the authorities could have evacuated those places which could be affected by tsunami beforehand if there was a anticipation. So the reasonable care should be taken to the extent it has been anticipated. Let's take an example. The principle, like we discussed, is if an injury is caused by the effect of natural forces and the natural forces are unforeseen and the effects are unavoidable, the defendant can claim the defense of act of God or vis major. Let's take the fact. The IMD, Indian Meteorological Department, predicts heavy rainfall in the coastal town of Hebri in Manipal, but true to its reputation or lack of it, it fails to predict the cyclonic rainfall. What they predict is heavy rainfall, and they give this information to usually when they predict something, they give this information to the authorities so that they can take reasonable care. However, it results in cyclonic rainfall, which they could not predict. As a result of this, the entire town is inundated and most houses sustain a lot of damage. So due to the cyclonic rainfall, this much damage is caused. Mr. Nayak, a social worker, sues the Hebri Nagar Panchayat for not warning the residents and taking sufficient precautions. So let's take the options. HNP, that is Hebri Nagar Panchayat, can take the defense of act of God. If the regular course of events has occurred and IMD has given this information to HNP, even though they had given to the information, they must have given the information of heavy rainfall. On the other hand, it results in cyclonic rainfall. So HNP can actually take the defense of act of God because they could actually help in heavy rainfall only, and they were not given the information of cyclonic rainfall, so they cannot take reasonable care. So the suit by Mr. Nayak, in the suit by Mr. Nayak, the HNP can take the defense of act of God. Let's take the other options also. HNP cannot take the defense since it should have foreseen such damage in the view of well-known ability of IMD to predict such things. HNP is incapable because they do not have the infrastructure and capability to predict the things, so they cannot predict in beforehand that there will be cyclonic rainfall in without taking into consideration that there was a prediction of heavy rainfall only. So they must have taken the reasonable care for heavy rainfall, not cyclonic rainfall. So this cannot be an option. Next is HNP cannot take the defense since it was aware of the possibility of heavy rainfall. Even though they were aware of heavy rainfall, they cannot take the reasonable care for the event of cyclonic rainfall, for which the suit has been taken to the court by Mr. Nayak. So this is also not an option. Next is Mr. Nayak cannot bring an action on behalf of the entire town. This is beyond option. This is outrightly wrong, that you don't have to go into such details that whether he can bring the action or not. This is upon the discretion on the court. So the answer is HNP can take the defense of God because it was not predictable on their part, and they could not take the reasonable care for cyclonic rainfall because it's the fault of IMD which they could not predict. However, Mr. Nayak can actually take a suit against IMD for not predicting it properly rather than taking a suit against HNP. Next defense is act of private defense. As the word suggests, if the defendant uses the force which is necessary for self-defense, he will not be liable for the harm caused thereby. It means that the person has a danger from another person for his property or right to life or his body. There's an danger of infliction of harm upon himself, then he can do any act or use such force which he will use to prevent such harm or injury due to the right of self-defense, and any harm caused to the other person would not be taken into the law of torts, and he will be given the defense of act of private defense. However, the important things to note is that use of force which is necessary. There should be reasonable force. We will discuss this in the examples. Justification for the use of force. There must be imminent threat that somebody is about to hit you, and then you stop that person by using the similar kind of force which is required, and there is imminent threat that you will get hurt by the act of other person who is going to hit you. So in that case, the defense of private defense would be available. The tricky area here is, like I said, we will discuss it in the example, the use of force which is not warranted. No imminent threat or force used for the retaliation or revenge. The force which was not required, like use of excessive force, these two things would be discussed in the example. Other guy attacks with a bamboo stick and you shoot him with you shoot him dead. You kill him by firing a bullet. The degree of force actually used was excessive. That person was hitting you with a bamboo stick, and the force you used was neither warranted and nor proper. It was an excessive force used by you to stop a person who was attacking you with bamboo stick, and you had shot him dead. So this is a unwarranted use of force and excessive use of force. So the degree of force actually used would be taken into consideration while deciding whether the act of private defense would be given to the person who is claiming that defense or not. Let's take a problem. Principle here is everyone has a right to defend their life and their property against the criminal harm, provided it is not possible to approach the public authorities. There's a new concept given in the principle, that there was a impossibility to approach the public authorities, and more than that, the necessary has not been done to avoid the danger. The person must do the necessary things which is a necessity at that point of time to avert the danger, to prevent yourself from the harm, yourself or the property, as it is given in this principle. Let's take the fact. The farm of X on the outskirts of Delhi was attacked by the gang of armed robbers. X, without informing police, at first warned the robbers by firing it in the air. As they were fleeing, he fired at them and injured a robber. Can he claim the right to defense? So let's see the principle again. You have a right to defend your life and your property, as in this case he was protecting his life and his farmhouse against the criminal harm which could be inflicted by the gang of armed robbers. He was protecting himself, proviso means there is an exception to it. There was no time to approach public authorities. He should have informed the police personnel before attacking them, or even using his gun for warning them and all. And the necessary has been done to avert the danger. So in this case, he had warned them by firing in the air, due to which they started fleeing. They were going away, but he then fired at them resulting in a injury to a robber. So in this case, it was not a warranted use of force. They were actually fleeing. There was no need to actually shoot them. So in this case, this use of power is unwarranted and excessive. So let's take the options. A, no, as he had not informed the police first and had acted in his own. So this case is about, can he claim the right to self-defense? So first option says no, because he had not informed the police first and had acted on his own. So this could be an example. Let's take second option, B. Yes, as he had every right to protect his property. Yes, he has a right to protect his property, but the excessive force was used. So this is not an option. Next is no, because he had used excessive force and had caused more harm than was required. So while solving questions, you must take the priority basis, that what principle says should be taken into consideration. In this case, A and B are the options which fit best on the principle provided, that he had the time to inform the police authorities, which he had not done and acted on his own. Second is that he has used excessive force to avert the danger. So the right option is both A and C. So in this case, he does not have the right to private defense due to both A and C reasons. Next is the defense of mistake. The definition says there is no liability in tort for the actions done in the honest mistaken belief. If there was an honest mistake on the part of the defendant, then he will be given the defense of mistake. Generally applicable in the case of malicious prosecution. We will be discussing the concept of malicious prosecution later on. Let's take an example for the defense of mistake. For example, A had a shop where he used to sell goods belonging to other people for a fixed commission. He used to charge some commission for selling the goods of other people on his own shop. So B told him to sell his goods. B came to him, gave him his goods and told him to sell his goods by A on his shop for the fixed commission. It turned out that the goods belonged to C. Later on, it was discovered that B was not the owner of the goods. They belonged to somebody else, that is C. Since A honestly believed that the goods were of B, and there was no liability of A in a tort. So in this case, he honestly believed because B convinced him to sell his own goods. So he had no chances, by no way he could anticipate or know that the goods were not belonging to B and belonged to C. So in this case, he would not be held liable for the tort because he honestly believed that the owner of goods was B, not C. So this is the defense of mistake which will be available to A. The important thing which is to be noted is that mistake of law, here mistake of law is no excuse. Mistake of a fact is acceptable excuse provided it was an honest mistake. Like we already discussed, it should be an honest mistake, but mistake of law is no use. If you are driving without wearing a helmet and then a police personnel, they put a challan on you, but you cannot take a defense that you did not know that there was a law and he was required to wear a helmet. You were required to wear a helmet as per the law. So mistake of law cannot be taken as a excuse. You have to follow the law even if you know them or you do not know the laws. Next two defenses are, first is necessity, another is statutory authority. First let's discuss necessity. Necessity: if a person commits an act causing damage in order to prevent a greater harm, he is not liable for the tort. It means a person has committed an act which causes damage in order to prevent a greater harm. In that case, he will not be liable for the damage occurred. Act caused damage done to prevent the greater harm. So there is a damage or injury which was done to prevent the greater harm. For example, throwing goods overboard to lighten the weight of a ship to save it from drowning. To save it from drowning. I'm sorry, there's a mistake. To save it from drowning. For example, you're on a ship and it starts droning. The pilot of the ship says that we have to throw the goods overboard to lighten the weight of the ship. So the harm or loss of goods has been done to prevent the harm, to save the greater harm, that would be saving the lives of the persons on the ship. So if you do not throw the goods overboard, it would result in droning of the ship, which will result in greater harm. So this lesser harm is done to prevent the greater harm, that is by saving the lives of the other people. Another example is trespassing into a house to save a person from burning in a fire. You're actually doing a offense of tort of trespass into somebody else's house for saving a person. So the offense or harm is done. It's a lesser harm as compared to the death of a person due to burning in fire. So the lesser harm is done to prevent the larger harm. So he will not be held liable for trespass in this case, because he was saving the person trapped in fire. Let's take another defense, that is statutory authority. Damage is the result of an act the legislature authorizes. If you are authorized by an act or law or statute by the parliament, if you've been given the authority to do such act, if any damage results due to that act, in that case you will not be held liable for the offense of tort. In that case, the defense of statutory authority is available to the defendant. Damage must not be a result of negligence. There must not be negligence on the part of the person doing the act. Must be only the result of authorized act. The authorized act is the only defense, but if there is negligence involved, in that case you would not be given the defense of statutory authority. For example, train accident as a result of negligence of driver would not be covered by the defense that the parliament has authorized plying railways. So train accident has occurred due to the negligence of driver. He is authorized to drive the train, and the authorization is given by the parliament for plying railways, but the negligence would hinder him from taking the defense of statutory authority. There must be no negligence involved in the act to take the defense of statutory authority. So in this case, he will not be given this defense. Let's take a problem. Principle: necessity knows no law, and any person facing a danger may do all that is necessary to avert the same till he can take recourse to public authorities. In this case also, public authorities come into action. It says that a person can do anything to avert the danger until he can take the recourse to public authorities. For example, he had no time to approach public authorities. For example, approaching police authorities was not an option at that time of the danger. So he can do all the acts which were necessary to avert the danger till the time he can actually contact police authorities. So we will keep this into mind while taking the facts into action. Facts are: Ankur, a law-abiding citizen, decided to remove the weed of corruption from Indian society. He took this responsibility on his own. One day, confronted with the bribing official, Ankur decided to teach him a lesson and punched him on the nose. The official filed a suit against him. So in this case, let's go back to the example. There must have been necessity to avert the danger. First of all, there was no danger to Ankur in this case, because the bribing official was not a danger to him, and there was a time for him and possibility for him to approach the public authorities if he had come to know that he was taking a bribe. So in this case, there was no harm which resulted in necessity to avert that harm, and there was a time to approach public authorities. So let's take the options and see what is the right answer. Ankur can plead the self-defense as he was being bribed, which is a crime? No, because there was no necessity in this case also to punch him in the nose. So he could have approached the public authorities if he was being bribed. Can plead self-defense as he could not have taken recourse to public authorities in the small duration of being asked a bribe. No, there was no imminent danger. If he had waited for 5 minutes or 10 minutes and taken the recourse to police authorities, even though the harm would not have been that much, so this option cannot be right. Cannot plead self-defense, as there was no necessity to act in the manner he acted. Like we discussed, there was no necessity to punch the personal in his nose just because he was taking bribe, because he had the time to approach the public authority. So this could be an option. Let's take the next option also. Can plead self-defense, as such aware and vigilant citizenry forms the basis of good democracy. No, this cannot be an option, because you cannot take law into your own hands. No, there's a protocol and the process which has to be followed for every crime and prosecution of a person who is doing any crime or offense. So in this case, he cannot plead self-defense, because there was no necessity in that situation to act in the manner he acted. So the offense of defense of necessity cannot be taken by the person. So thank you for being with us.